Judge. How are you?
Subcommittee will now come to order. I'm pleased to welcome you today to the hearing before the Subcommittee on Crime, Terrorism, and Homeland Security on H.R. 2289, the Juvenile Justice Accountability and Improvement Act of 2009. The United States is the only country on earth that sentences children to die in prison. While other countries have abolished this practice, we continue to impose this sentence at alarming rates, and in 14 states, children as young as 8 years old can be sentenced to life without parole. Currently, the United States has over 2,500 people in prison serving life sentences without parole for crimes they committed as children. For the majority of these juveniles, it was their first offense. What is alarming is that over 2,000 of the 2,500 plus juvenile life without parole sentences resulted from mandatory minimum sentencing guidelines that required the court to impose the life sentence. In 29 states, once a youth is convicted of certain crimes, the court must impose life and cannot give consideration at sentencing to either the child's age or life history. Whether or not these mandatory minimum sentences were intentionally designed to penalize such a large number of juvenile offenders is not clear. A recent case, Enri Nunez, seems to indicate that the sentencing of some juveniles to life without parole is an unintended consequence of harsh mandatory sentencing schemes originally designed for adult offenders. In Nunez, the court compared California state sentences for first-degree murder and for kidnapping for ransom that does not result in injury. Under current laws, a 14-year-old convicted of kidnapping for ransom that involved a substantial risk of death, but no death or even injury occurred, they would receive a mandatory life without parole sentence. Had the offender murdered the victim and been convicted, the harshest sentence that he could have received would be life with parole. The inconsistency between these two sentencing schemes implies that at least some juvenile life without parole sentences have resulted because of legislative oversight as opposed to any deliberate legislative intent. What is also of concern is that over a quarter of youth offenders serving life without parole sentences were convicted of felony murder. Under felony murder laws, a teen who commits a non-homicide felony, such as robbery, is held responsible for a co-defendant's act of murder that occurs during the course of the felony. State laws do not require the child offender to have intended or even known that murder would take place, or that he even participated, even that the other participant was armed. He might not have even known that. These felony murder convictions are problematic when we consider that many of the juveniles serving these sentences committed their crimes with adult co-defendants. In California, for example, 70% of the juvenile life without parole cases in which a teen was acting with co-defendants, at least one of the co-defendants was an adult. In over 50% of these cases, the adult received a more lenient sentence than the teen, even though the children generally were neither the ringleaders, sometimes not even directly involved. For example, a 13-year-old juvenile, if a 13-year-old juvenile joins a 25-year-old brother in stealing a car and going on a joyride, while the 13-year-old juvenile waits in the stolen vehicle, his older brother stops at a drug house and murders someone. Because the 13-year-old juvenile helped steal the vehicle that was used to drive to the drug house, under the felony murder rule, he will be held accountable for the murder that his brother committed, even if the juvenile did not know of the plan. Now, scientists have revealed that children's brains are underdeveloped in areas dealing with impulse control, regulation of emotions, risk assessment, and moral reasoning. During adolescence, neurological structures most critical to making good judgments, as well as moral and ethical decisions, are still being developed. Additionally, because of their low social status in relation to adults and their dependency on adults, juveniles are uniquely susceptible to coercion and intimidation by adults. For these reasons, the United States Supreme Court has found that sentencing children to death violates the Eighth Amendment's prohibition against cruel and unusual punishment. The California Senate recognized this fact and recently passed legislation allowing courts to review juvenile parole cases after 10 years and, if appropriate, re-sentence the offender to a new sentence of 25 years to life. While juvenile life without parole is often imposed on children offenders who have been convicted of crimes of homicide Life without parole is also imposed on a variety of other crimes, including assault, carjacking, robbery, molestation, burglary, drugs, and grand larceny. In many of these instances, the crime resulted in no death. In the case of Sullivan v. Florida, before the Supreme Court this coming term, a 13-year-old was sentenced to life without parole in Florida after being convicted of sexual battery. In a second case to be heard by the Supreme Court this term, Graham v. Florida, a 17-year-old on parole was sentenced to life without parole for taking part in an armed home invasion, which also did not result in a murder. The issue before the Supreme Court is whether these cases, in either of these cases, whether or not there is a violation of the Eighth Amendment's prohibition of cruel and unusual sentences. There also appears to be a discriminatory impact in life without parole sentences. African American youth, on average, receive juvenile life without parole sentences 10 times more often than white youth. In Connecticut, Pennsylvania, and California, this disparity is even greater, with black youth being sentenced 18 to 28 times more often than those of white youth. In the bill before us, we are not seeking to prohibit the incarceration of juveniles for life sentences or mandating their release. The bill simply provides juveniles sentenced to life or the equivalent. The bill simply provides for juveniles sentenced to life or the equivalent a meaningful opportunity for a review, and possible parole must take place. Only after serving 15 years of incarceration, and then only at intervals of 3 years thereafter, will juveniles be allowed a chance to show that they are worthy of parole. And we recognize the pain and suffering of the victims of child offenders, and the need for closure in these cases. For this reason, the bill provides for victim notification requirements in an effort to protect these victims' rights and understandable sentiments. However, there are several states that do not sentence juveniles to sentences of life without parole, which manage this need against the need for society to recognize that there are irrefutable scientific differences between juveniles and adults in their ability to make responsible decisions. We recognize these differences in many ways. Juveniles can't vote. Juveniles can't serve on juries, can't drink, smoke, or serve in the military, can't sign contracts, play the lottery, and so forth, because they are not viewed as having the mental capacity or maturity to responsibly do these things. Yet we toss aside all science and reason regarding the mental capacity of juveniles when it comes to crime. We addressed this issue in a reasonable manner over 100 years ago through the establishment of a juvenile court system. However, we have allowed the emotions and politics of crime to roll back the provisions of that system to substitute the harsher adult system in not just serious violent crimes, but in a whole host of other areas. We continue to do this in spite of the fact that every credible study now reveals that treating juveniles as adults generally results in them committing more serious crimes and sooner than similarly situated children sentenced as juveniles. So we look forward to hearing from the panel on how we can address the issue of why we are the only country in the world to sentence children to die in prison, sometimes for relatively minor involvement in crime. It's my pleasure to recognize the esteemed ranking member of the subcommittee, the gentleman from Texas, Judge Gohmert.
Thank you, Chairman Scott. Today, the Crime Subcommittee will review H.R. 2289, the Juvenile Justice Accountability and Improvement Act. This bill requires states to give parole reviews to juvenile offenders who are sentenced to life without parole. This bill seeks to regulate prerogatives sentencing of convicted criminals. That is exclusively a state issue. As most law professors and lawyers know, but some forget, states have exclusive control over the prosecution and sentencing of defendants within their jurisdiction unless their laws violate a constitutional right. In the 1990s, the overwhelming majority of state legislatures adopted sweeping changes to their juvenile criminal codes to properly address what the juvenile justice system had overlooked. The protection of public safety is a paramount concern, whether the offender is juvenile or adult. These state legislatures revised their codes to allow juveniles charged with serious violent crimes to be tried as adults to ensure that a juvenile offender was not sentenced less seriously for their criminal behavior solely because of their age and perceived immaturity. They also reasoned that juveniles who pause to consider the consequences of their conduct before committing crimes will be deterred if they face harsh sentences such as life in prison without parole. Presently, 39 states allow for juveniles to be tried as adults and sentenced to imprisonment for life without parole if they are convicted of violent crimes such as murder. In some states, a sentence of life without parole is mandatory if a juvenile is convicted of certain crimes. In other states, the sentencing judge has discretion as to the sentence. In its next term, the Supreme Court will consider the constitutionality of sentencing certain juveniles to sentences of life without parole. In making its decision, the court will consider two cases involving offenders who committed crimes that did not result in the death of a victim. That's a slightly peculiar choice of cases, considering that Amnesty International tells us that almost 93% of juveniles serving life without parole were convicted of homicide. When making its decision in these cases, I hope the court is mindful that prosecutors consider a number of factors when they determine whether to charge a juvenile defendant as an adult. Included in those factors are the nature and circumstances of the offense, the impact of the offense on the victim, and the juvenile offender's criminal history. As a result of this deliberative process, very few juveniles are charged as adults. According to the National District Attorneys Association, most jurisdictions in America prosecute only 1 to 2% of juvenile criminal offenders as adults, and in some jurisdictions this percentage is even lower. These states give prosecutors that discretion because the state legislatures and the constituents that they represent have determined that tough sentencing is required to punish offenders that have committed murder and other violent crimes to deter others from committing similar crimes in the future. H.R. 2289 violates the principles of federalism that are the foundation of our legal system. And it is inappropriate at best and unconstitutional at worst for Congress to seek to regulate the manner in which states determine appropriate sentences for state crimes committed and prosecuted within their jurisdiction. I'm also concerned that H.R. 2289 is an unfunded mandate that would impose costly financial obligations on a number of states. 11 states and the District of Columbia have determined sentencing systems that do not allow parole. In order to implement the requirement of H.R. 2289, these states would presumably have to create, fund, and maintain a parole board to conduct hearings solely for this particular class of juvenile offenders. The bill unreasonably threatens to withhold burn-jag grants from the states unless they comply with its mandates. This threat forces the states to make the 10th Amendment negating decision to substitute Congress's judgment for its own regarding criminal sentencing or risk losing important funds that help state and local law enforcement officials accomplish their missions. Further, a federal mandate that a state provide parole reviews for one class of offenders that is not available to other offenders could create other issues of constitutional proportions. Under this bill, two co-defendants in a murder prosecution here in Washington, D.C., one who is 16 years old and one who is 19 years old, could be tried as adults and convicted of that crime, and both sentenced to life in prison without parole. However, this legislation would require the jurisdiction to give periodic parole reviews to the 16-year-old, while the 19-year-old would face life in prison. Two individuals who committed the same crime would receive two different punishments. From a personal standpoint, I never sentenced anybody to life without parole. We didn't have that when I was a judge in Texas. And I would find it a difficult matter to do, especially for someone very young, because you can consider age in determining sentencing with regard to mitigation. But I also believe in the constitutional system we have that my judgment as a member of Congress should not be substituted and forced onto a state in which I don't live and in which I'm not part of their legislature. So, and I appreciate the chairman's comments and the lists about things children can't do, but I would note that juveniles are allowed to legally abort or kill their unborn children. So that is still apparently a constitutional right as well. Personally, I don't like the idea of sentencing children to life without parole. It's repugnant, but that is a matter for the states, and I hope my state will not do that. But with that, I yield back and appreciate the chairman's indulgence.
Thank the gentleman. I think we have switched sides on what the states ought to do, because we've been trying. And so I agree with, we should not normally do this, but I think this is an exceptional situation. But we have a distinguished panel of witnesses here to help us consider the important issues that are currently before us. I ask each of the witnesses to complete his or her statement within 5 minutes, and there's a lighting device before you on the table, which will turn from green to yellow when there's 1 minute left, and red when your time is up. All of the witnesses' statements will be entered into the record in their entirety. Our first witness will be Professor Marc Osler of Baylor Law School. He is a former federal prosecutor and has argued cases in 6 federal courts of appeal and the United States Supreme Court. Most recently, as lead counsel, he won the case of Spears v. United States in 2009 in the Supreme Court, where the court held that sentencing judges can categorically reject the 100-to-1 ratio between crack and powder cocaine in the federal sentencing guidelines. He's a graduate of Yale Law School and serves as the head of the Association of Religiously Affiliated Law Schools. Next panelist will be Dr. Linda White. She is a former adjunct faculty member at Sam Houston State University, Huntsville, Texas, in the Department of Psychology and Philosophy. She holds a B.S. degree in psychology and an M.A. in clinical psychology from Sam Houston State University, and earned her Ph.D. from Texas A&M. Mrs. White's 26-year-old daughter was abducted, raped, and murdered in 1986. She is a volunteer mediator with the Victim Offender Mediator Dialogue Program in the Texas Department of Criminal Justice, and was appointed in 2003 by Governor Rick Perry of Texas to represent victims' issues in the Texas State Council for Adult Offender Supervision. She is a member of the Murder Victim Families for Reconciliation and a board member of the Texas Coalition to Abolish the Death Penalty. Our next panelist is Jennifer Bishop-Jenkins. She is the sister of Nancy Bishop-Langert, who was brutally killed along with her husband and unborn child in a highly politicized killing in Illinois. In 2007, she co-founded the National Organization for Victims of Juvenile Lifers to protect victims' rights. After a 25-year high school teaching career, she has been working as a national program director for victims and survivors of gun violence and serves as a member of the advisory board to a nonpartisan United States Congressional Victims' Rights Caucus. Our next panelist is Anita. She is, in addition to her day job in human services, she is a human rights and juvenile justice advocate. Her brother, Robert Holbrook, was sentenced to a life sentence when he was 16 years old after a neighborhood drug dealer asked him to serve as a lookout during a drug deal that turned into a robbery and a murder. She serves as the Pennsylvania State Coordinator for the National Campaign for Fair Sentencing of Children in Springfield, Pennsylvania. She is also a member of the Pennsylvania Prison Society's Subcommittee focused on juvenile life without parole and chair of the Juvenile Life Without Parole Steering Committee of Reconstruction Incorporated. She attended Villanova University, where she majored in criminal justice and obtained a master's degree in human services from Lincoln University. Our next panelist is James Fox, District Attorney in San Mateo County, California, and a board member of the National District Attorneys Association. He attended the University of San Francisco School of Law and has a degree in psychology. He is a board member of the Mercy High School and Junipero Serra High School, and is also a member of the Criminal Law Advisory Committee of the Judicial Council of California. He will be testifying on behalf of the National District Attorneys Association. And last but not least is Marc Maurer, the Executive Director of the Sentencing Project. He is one of the country's leading experts on sentencing policy, race, and the criminal justice system. He has directed programs in criminal justice policy reform for 30 years and is the author of some of the most widely cited reports and publications in the field, including Young Black Men in the Criminal Justice System and Americans Behind Bars series comparing international rates of incarceration. He is a graduate of Stony Brook University and earned a master's in social work from the University of Michigan. So we'll begin with Professor Osler.
Mr. Chairman, members of the committee, good afternoon. My name is Marc Osler. I'm a former federal prosecutor, and I currently have the honor of serving as a professor of law at Baylor Law School. My teaching and my study concentrate on sentencing and questions of faith related to criminal law, and I welcome this chance to address the issue of life without parole for juveniles. My testimony is going to focus on placing this bill in context, both the larger context of broad changes in sentencing and the idea that this bill is consistent with a principle that's a part of the faith of many Americans. I believe in punishment, and I believe that the incarceration of the violent and the dangerous in our society is necessary to an ordered society. I'm proud of my work as a prosecutor in the city of Detroit, in the Eastern District of Michigan. Things changed in that city in 1978 when a drug gang called Young Boys Incorporated took over much of the heroin trade in that city and pioneered the use of children as runners, drug sellers, and killers. The template was copied by others, leading to a disheartening rise in the number of children accused of very serious crimes, the type of crimes which result in the penalty of life without the possibility of parole. As an academic, I study sentencing, and I recognize where this bill fits into some of the larger trends we see right now. The changes being proposed are not sweeping. Rather, this bill is consistent with a general movement to right-size the relationship between retribution, rehabilitation, and relative culpability. In short, this bill does not seek drastic change, but rather an incremental adjustment that would affect a relatively small number of cases. This is consistent with what we see in other parts of sentencing right now. For example, instead of wiping out the sentencing guidelines or mandatory minimums across the board, members of this committee have proposed correcting the federal sentencing element that is most unfairly retributive, the sentencing ratio between powder and crack cocaine. And we've seen similar movement in the Sentencing Commission itself. Capital punishment has also seen incremental changes, not abolition. The 2005 case of Roper versus Simmons, already mentioned, barred execution for juvenile crimes. And that's significant, but only affected a relatively few cases. As state criminal justice systems adjust to new budget realities right now, they consistently are considering incremental changes rather than broad or across-the-board and drastic changes. In contrast, the year 1984 was a time of drastic change. In 1984, Congress got rid of parole, began the process of formulating strict and mandatory sentencing guidelines, and passed the Bail Reform Act, which for the first time created presumptions against release pending trial, even in relatively minor drug cases. Federal sentencing was transformed in a single year. This is not 1984. Rather, the present project, which includes this bill, seems to be to find a balance between retribution and some kind of human element in the system. This search for balance draws from our deepest principles. Famously, Micah 6:8 advises, "What does the Lord require of you? To act justly, to love mercy, and to walk humbly with your God." That passage reflects two values. Retributive justice is one of them, and mercy is the other, and those two are in tension with one another. It's difficult to resolve that tension other than to recognize that our system of justice should not be all retribution or all mercy, but must have some elements of both. This bill seeks exactly that balance. A sentence of life without the possibility of parole allows no room for mercy or redemption, an imbalance which is particularly untenable when we're talking about children as offenders. I can't pretend that this is an easy issue. As a small child, our family was close with our next-door neighbors on Harvard Road in Detroit. We children would play outside as the parents sat on the porches and watched. We remained close as those families moved and the children grew up. In 1990, the father in that family was shot and killed by a group of 15 and 16-year-old children who were trying to steal his car. Two of the defendants received life without parole sentences for killing this man that I often ran to with skinned knees or exciting news. I saw directly the righteous anger and pain of his widow and his children. And though this issue is difficult for those of us who have known or been victims, we should not look away. I fear that part of what we do when we lock up a child forever is absolve ourselves, the adults. Yet an examination of the lives of child offenders reveals something different. What we would like to see as pure evil in that child is too often a product of what we've tolerated in our community of adults. The shocking thing about Young Boys Incorporated was not just that children committed murders and sold drugs on the command of adults, but they were made to do that for 8 years, that organization thrived in plain sight on street corners. For 8 years, we tolerated an organization that did such incredible harm and addressed it largely by arresting the children who were involved. The easy answer is to ignore those questions and push all of the evil onto the child, but to do so is wrong. To lock up a child forever is against our good and present impulse to back away from the most severe retributive sentences. And it's also against a faith imperative, the balance between justice and mercy, which informs Americans when we are at our best. I've also submitted written testimony today, and I thank you for the opportunity to address these important issues.
Mr. Chairman and members. Mr. Chairman and members, thank you very much for the opportunity to discuss the issue of life without parole, and specifically this bill, H.R. 2289. Until November of 1986, I was not very knowledgeable or very interested, to be quite frank, in criminal justice matters in general, and certainly not juvenile justice matters. That changed quite suddenly and dramatically late that November when our 26-year-old daughter, Kathy, went missing late that November and then found dead following sexual assault by two 15-year-old boys. I spent the better part of a year in limbo awaiting their trials, as they had both been certified to stand trial as adults. During that time, the only information I had on either of them was that they had long juvenile records. There was never any doubt about their guilt, as they had confessed to the rape and murder and led the police to her body after they had been detained by the police in another city in Texas. The court-appointed attorneys for both pled them out, and they were sentenced to long prison terms with no chance at parole for at least 18 years. They came up for parole in 2004, were both given 5-year set-offs, so they remain in prison at this time. I assume they will come up again later on this year. You've heard in my bio that I taught at Sam Houston State University. During the time that I taught at the university level, I taught upper-level college courses for 8.5 years in prison. The most rewarding work I have ever done, and the most healing for me as the mother of a murder victim. In addition to the formal schooling that I've had, I have also educated myself in the area of criminal justice. I heard a lot of information when I attended victims groups, and I wanted to know for myself if it was accurate. I have found out for the most part it was not. One notable example is that Texas prisons are about as far as you can get from country clubs. Many of our citizens, and certainly victims of crime, want men and women who are convicted of criminal activity to suffer as much as possible in prison, believing that this is the way they will turn from a life of crime. I no longer believe this to be true and have become a devout believer in restorative justice. It doesn't mean that I think incarceration is always wrong, but neither do I believe that it should be our first inclination for juveniles or for adults. As a psychology student and teacher, I have learned that while it may be necessary to remove offenders from our midst for a time, punishment is often the least effective means to change behavior and often has negative side effects. I have to admit to you that my journey to healing after my daughter's murder was different than what I often see in victims and survivors. For I concentrated on healing for my family and me, and because I focused on education over the years. At first it was education about grief and loss, and later on it was about psychology and death and dying. Eventually it became concentrated in criminal justice because of so much that I saw in our system was violent, perhaps necessarily so at times, but still, nevertheless, it seemed to me that we returned violence for violence. As I said previously, for many years, I only knew that the boys who killed my daughter were juveniles with long criminal records. In 2000, I found out that one of them, Gary Brown, was willing to meet with me in a mediated dialogue as part of a program that we have in our Texas Department of Criminal Justice Victim Services Division. He was apparently very remorseful by that time and had prayed for a chance to tell us just that. With our mediator, we did a lot of reflective work getting ready for our meeting. And during that time, most importantly, I found out from Gary's records that his long juvenile record began at the age of 8 with his running away from abusive situations, both at home and in foster care eventually. If I were being abused emotionally, physically, and sexually, I think I'd run away too. It seems quite rational to me. I also found out that his first suicide attempt was at the age of 8, the first of 10 attempts. I have a grandson just about that age right now, and it breaks my heart to think of a child like that trying to take his own life because it is so miserable. Seeing how little time I have left, I just want to say that I have been deeply blessed by the work that I have done in prison and out of it in the field of restorative justice. And all the years of education that I have had have pointed me in the direction that young people are just qualitatively different from the adults that we hope they will eventually become. And I think that my experience with Gary has shown me that we have a responsibility to protect our youth from the kind of childhood that he had and from treatment that recklessly disregards their inherent vulnerability as children. Sentencing youth to life without parole strips our young people of hope and the opportunity for rehabilitation, and it ignores what science tells us, that youth are fundamentally different from adults, both physically and emotionally. Even given what my family suffered, our incredible loss, and believing that young people need to be held accountable, I believe that they need to be held accountable in a way that reflects their age and their ability to grow and change. Thank you.
Thank you, Mr. Chairman and members of the committee. My name is Jennifer Bishop-Jenkins, and I'm one of the founders of the National Organization of Victims of Juvenile Lifers. In 1990, my sister Nancy, her husband Richard, and their unborn child were brutally murdered in Winnetka, Illinois, by a young man 4 weeks shy of his legal adulthood. He planned the murders alone and reportedly did it for the thrill of it. He shot Richard in the back of his head and then turned the gun on my beautiful young sister, who begged him not to kill her baby. He fired directly at her abdomen, exploding the baby, leaving Nancy bleeding to death. And Nancy's last act of life was to draw a heart and a U in her own blood. I have devoted the relative peace and legal finality that his 3 natural life sentences brought us to the prevention of violence and advancing human rights. And I have come here to tell you that the bill before us is actually deeply flawed. It is the antithesis of due process, and it is a violation of fundamental victims' rights to even consider retroactively changing life without parole sentences, certainly not without informing and involving the victims. Our family's experience illustrates the rank unfairness. We were promised life without parole by a judge who chose to exercise a discretionary life sentence for such a heinous crime because of his privileged upbringing and a complete lack of remorse. And relying on that promise, we believed this part of our ordeal was over. So, we don't have transcripts of the sentencing. The court reporter with his stenographic tapes cannot be found. We can't contact the jurors. My father, the best witness to the carnage of the crime scene, has died. We can't get statements from prosecutors, evidence technicians, and police who had direct contact with the case. Witnesses cannot now be found, such as Nancy's next-door neighbor, who heard her terrified pleas for help, and the friend of the killer to whom he confided details of the awful crime. All that we could have gathered to arm ourselves for a parole hearing someday is lost. Lost because we were promised that parole or early release for this killer was not possible, and this is a sickening bait and switch. I have used my own limited resources to notify a few other victims of this well-funded national effort to free these killers. All were told the same thing. Don't worry, this guy can't ever get out. This new uncertainty renders our situation entirely different from victims like Linda White, because though she and I have worked together a long time as murder victims' family members devoted to restorative justice and human rights, as she herself told you, I'm sad to say she literally has no standing in this specific discussion because the offenders in her case did not receive this sentence. The temerity of anyone to propose anything that so profoundly affects us without notifying us is appalling. If you haven't gone through it, you cannot understand the impact of this proposal before us. Parole hearings are incredibly re-traumatizing. They deprive victims of legal finality. To reopen this pain every 3 years for the rest of our lives, and perhaps those of my children, is quite literally torture. Proponents of this legislation will be hard-pressed to produce one victim's family like ours, where the offender had no relation to the victim, who actually wants to endure this lifetime of parole hearings. They will no doubt give you some rare, legitimate stories of injustice that, like all problems in the criminal justice system, can and should be addressed. But we can easily outmatch them with horror stories, such as 12-year-old Victoria Larson, whose killer dug her grave 3 days before raping and killing her. He had already been given his second chance. He was already out on juvenile parole, and a parole that he used to rape and murder her. And the 16-year-old who took the 5-year-old girl into the abandoned housing project in Chicago and raped her, and then threw her out a 14-story window. As she clung with fingertips to the windowsill screaming for her mother, he went to the window and lifted off her hands, sending her to her death, 5 years old. This is not impulse. This is callous disregard for human life, with cool advanced planning by people old enough to know that killing is wrong. I note that this room is not filled with victims' families of these crimes. I promise you it is not because they do not care. It is because no one has bothered to tell them that you are doing this. Despite our pleas to this committee for victim notification in advance of legislation, and our pleas to the advocates of these offenders, who have spent millions supporting them, that they devote a small nominal proportion to outreach to victims' families of these crimes. My written testimony will detail other important issues pertaining to this legislation, such as how the brain development research is actually being misapplied, how a one-size-fits-all parole mandate cannot work in a nation where each state has a different sentencing scheme, including half of them with determinate sentencing and many of them, like my state, with no parole structures at all, and ways that juvenile life sentence can actually be reformed, as I believe it can, without any negative impact on victims using different ideas. We all need a real conversation about reforming this process before the filing of any more such legislation, and with all the stakeholders at the table. And in the meantime, as this bill stands now, it only transfers the life sentences from the guilty offenders to the innocent victims' families left behind. Thank you.
Thank you. Ms. Colon.
Good afternoon, Chairman Scott and committee members. First, I would like to thank you, Chairman Scott, for introducing H.R. 2289 and for holding this hearing. I commend you for your concern over the issue of sentencing juveniles to life without parole, as well as your willingness to step forward to address it. My name is Anita Colon, and I am the sister of Robert Holbrook, a man convicted, currently serving a life sentence in Pennsylvania for a crime he was convicted of at the age of 16, a crime that occurred on his 16th birthday. That day, lured by the promise of $500 made by a drug dealer, Robert agreed to serve as a lookout for 4 adult males for what he thought was going to be a simple drug deal. My brother soon found himself in the midst of a robbery of a drug dealer's wife inside her home. Although he desperately wanted to run once he realized what was happening, he was terrified of the drug dealer that had ordered him to stay and oblivious to the consequences that would await him if he remained. As a result of that terrible night, tragically, a young woman lost her life. Because of the terribly misguided decision my brother made, his freedom was taken away forever. Having no prior experience with the court system, my brother accepted his attorney's advice and pled guilty to murder generally. The attorney told us that if he did not do this, the DA would seek the death penalty. Despite the fact that Robert was a juvenile, had no prior criminal record, and did not participate in the actual murder of the victim, the judge imposed a sentence of first-degree murder for aiding and abetting in the crime. Because of mandatory sentencing in Pennsylvania, he was sentenced to life without the possibility of parole. At his sentencing, the judge stated that my brother had certainly been the least culpable of the offenders, but that the law did not permit him to use discretion in his sentencing. That was over 19 years ago, and my brother is now 35 years old. While his friends continued high school, got their driver's licenses, went on to college, got married, my brother spent the majority of his most defining years in prison. Most of his early years were spent in isolation, separated from the adult offenders because of his age. Here he was locked up for up to 23 hours in a day in a cell the size of a small bathroom. My brother's conviction and incarceration was devastating to my family, especially my mother. My mother wrote to her son in prison each and every day right up into the end of her life 4 years ago. At that time, she had been diagnosed with cancer, and within months she passed away. My brother was not allowed to attend her funeral because the Department of Corrections no longer permits the transporting of lifers to attend funerals, even when a parent dies. Despite being told that there is no hope for him, my brother has refused to give up on his life. While in prison, he obtained his GED, participated in many college and paralegal courses, and became an avid reader and writer. He has had several articles published and works closely with many human rights organizations. My brother deeply regrets his participation in the crime and the horrible loss suffered by the victim's family, but does not believe that his entire life and hope for the future should be taken away from him. Whereas that I also believe my brother's action that day did warrant punishment, I am confident that he does not deserve to spend the rest of his life, what could turn out to be 60, 70, even 80 years in prison, for one horrible choice he made while barely 16. Although my initial concern over juvenile sentenced to life without the possibility of parole came as a result of my brother's conviction, after truly researching this issue, I became an advocate for juvenile justice reform. And I'm speaking to you today on behalf of the approximate 2,500 juveniles currently sentenced to die in prison throughout the United States. Our laws do not allow juveniles to assume the same responsibilities as adults, such as driving, voting, drinking, joining the military, because we know that they are not mature or mentally developed enough to make these decisions or control these actions. Yet we hold these same children as accountable as adults when it comes to crime. Juvenile offenders should not be held to the same level of accountability as adults because they are not adults. These youth are not beyond redemption, but currently they are without hope. In my home state of Pennsylvania, we have the distinction of having the highest number of juvenile lifers of anywhere else in the world, with approximately 450 prisoners serving life sentences for crimes they committed or participated in as juveniles. The district attorney's office claims that only the worst child offenders are sentenced to life without parole, and only in exceptional circumstances, but that is simply not true. While I acknowledge that those fighting crime throughout this country face daunting challenges, the answer is not to throw away the lives of our children forever. The fact that a child commits a crime does not negate the fact that they are still a child. Please understand that I am in no way suggesting that you open the prison gates and free everyone that was incarcerated as a juvenile. This legislation would provide these offenders the prospect, not guarantee, of parole after a reasonable period